So good morning, everyone, and welcome to this first panel of the symposium. Since this is the opening panel and on stage we are all Portuguese, I would like to take this opportunity to warmly welcome to Lisbon, and I hope you enjoy these days in our lovely city. My name is Joana Pinto. I'm a senior legal counsel at Accenture Portugal, and it's an honor to share this opening panel about collective redress in Portugal. With me on stage, I have three lawyers of three leading law firms in Portugal. Rita Samoreno Gomes, partner at PLMJ and co-head of PLMJ Dispute Resolution Team. In the recent years, Rita has been focusing on class actions, working essentially on the defense side. Rita has a large experience in this area and is currently defending more than 1,000 class actions, most of them representing large international corporations. Sofia Vaz Sampaio, litigation partner at Morais Leitão. She has been involved throughout her career in high-profile commercial and civil cases, also focusing on banking and financial litigation. Sofia started working in class action in the wake of the financial crisis and has since then gained extensive experience in this area. Currently assisting domestic and international clients in dozens of actions where she works closely with different departments within the firm. Joana Neves, managing associate with Vieira, in Vieira da Almeida e Associados in litigation practice. She has been involved in complex litigation matters, including contract and financial disputes, corporate and shareholders disputes and professional liability. Joana's more recent work also been focused on class actions, consumer protection, and technology and software disputes. She is currently assisting national and international clients in several collective actions across a variety of sectors. Portugal is at a pivotal moment for class actions. These actions are becoming more relevant, and in today's discussion we will look at the main developments on this area, challenges ahead, and the growing importance of this mechanism as consumer protection. Without further delay, let's start with Rita. The right to bring class actions in Portugal exists since the 60s and was refreshed by the introduction of the Popular Action Law in 1995. At this stage, Rita, my understanding, as already been said today, the class actions have boomed in Portugal in the recent years. Why do you think that is?
Well, first of all, many thanks for the kind introduction, Joana, and many thanks to GLG as well for inviting me for this event. I'm honored to open the panel discussion, especially after hearing Maria José, our keynote speaker, who is always a pleasure to hear, although not rarely we are on opposite sides, but always a pleasure to share experiences and insights. It is true that the class actions are a current trend in Portugal, and I think that the fact that this event attracted such a wide, diverse and sophisticated audience is really a testament to that. I think it's not only the sun, but the sun. I know that the sun plays a role, but I believe it's not only the sun. So this is really a testament of how active and attractive the class action actually is in Portugal nowadays. It is true, Joana, that class actions have boomed in the recent years, more or less since 2020. I think that a combination of factors have played a role in that. First of all, we do have the legal regime. We do have an extremely claimant-friendly legal regime. Portuguese class actions right stems from the Portuguese constitution, and we have not only the popular action law since 1995, which was deemed as a very state-of-the-art law back in 1995, but we also have been passing new laws that have been enabling class actions to be able to be lodged and progress. I'm thinking about the Private Enforcement Act and also the Representative Actions Directive, which Portuguese state has transposed into law last year. Also, I think that a big factor was the emergence of very active stakeholders in the claimant side, be it consumers associations, claimant law firms, litigation funding, with ever-growing attention to what is happening in other jurisdictions and taking advantage of the good legal regime that we have in Portugal and the experience that other countries have to bring very complex and sophisticated class actions. We have currently more or less, I would say, 3 active associations, consumers associations in this area. 2 of them are linked with international claimant law firms, other EU consumers associations. So there is clearly an exchange of insights and of experiences. We have been, Joana will be talking about the profile of the class actions that have been filed lately in Portugal. Some of them target domestic corporations, but you may be surprised not only by the numbers that Joana will give you, but also by the fact that there are many large international corporations that have been targeted by class actions in Portugal. And we do have a legal regime that we have to put forward a full defense at a very early stage of the proceeding. So this specific feature of the Portuguese regime not rarely has the consequence of, in case of class actions that are lodged in multiple jurisdictions. In Portugal, many times defendants find themselves in a position in which they need to put forward, it is the jurisdiction in which they need to put forward a full defense, which is probably something that they wouldn't be expecting. So also on the back of that characteristic of the Portuguese regime, the Portuguese class action market has been becoming more increasingly important, and I think that this is no longer a phenomenon that is contained within the Portuguese jurisdiction, and it has many potential spillover effects to other jurisdictions, which is something that, well, from experience I know that international entities would not be expecting Portugal to end up leading the strategy, the defense strategy in multi-jurisdictional class actions. I'm conscious of time.
No, I was about to. I think. Okay, thank you. About to building on that, your view about how effective the class actions are in Portugal as a mechanism to consumer protection.
Yeah, well, I think that we have a very good state-of-the-art legal regime in terms of enabling class actions. I was hearing very, very attentively Maria José, and I do think that the Portuguese regime, in terms of regime, I think it ticks all the boxes that Maria José has highlighted as the features that a regime needs to have to be able to to enhance collective redress. We are an opt-out regime for more or less 30 years. We don't have a proper certification stage, and judges have wide powers to relegate the decision on procedural issues, preliminary issues, to the end of the case. So this makes it very easy for cases in Portugal to proceed to trial. So we have very few checks at the entrance. It is very easy for a class action to proceed to trial. We also do have the Global Compensation Award feature, and as Maria José was mentioning, in Portugal, Portugal is one of the countries in which unclaimed compensation awards do not revert back to defendants, they revert back to the Portuguese state, and in some instances, claimants are also able to recover litigation costs with the unclaimed amounts. So we are really a very, very good claimant-friendly jurisdiction in terms of regime. Now, to your question, I don't want to miss your question, obviously. Well, how effective these class actions are in Portugal in terms of protecting the consumers' rights, I think that the answer to that depends very much on what you mean by effectiveness. If you mean that, by that, whether redress in whatever form, compensation, repair, contract termination in whatever form, has effectively reached to the hands of consumers, I think that the answer would have to be no. Mm-hmm. Joana will also elaborate a bit more on that, but since this surge of class actions since 2020, I think that if I'm well informed, I think that we have one judgment on the merits that determined that the restitution by the defendant of certain amounts to consumers. That decision is still being discussed in terms of the liquidation of the damages, so no distribution to consumers yet. There have been some minor settlements in an impactful injunctive class actions, and as far as I know, only one settlement has been reached in a compensatory class action. This is a settlement that was obviously approved by the court, because that is required by Portuguese law, and the settlement involved the compensation to consumers. Unfortunately, and although this settlement was reached in 2021, no one claimed their compensations in that case. So zero claims for consumers, and I think that the window for claiming compensation in that case, all windows are, I think, closed. But I think that if we have a settlement in which zero consumers claim for their compensation, I think that this is definitely food for thought. Mm-hmm. I think that the idea, answering to your question, the idea that comes into my mind is that class actions in Portugal are still a work in progress, and although we do have a surge in class actions, although we have a far-reaching regime with lots of potential, that doesn't mean that redress has reached the hands of consumers. So I don't think that we have closed the circle yet. We have a long way to go. So I'm conscious of time, and I'm gonna stop here.
We have a path away, and thank you for setting the scene. And I like the challenges. Sofia, building on Rita's observation. Did the transposition of the Representative Actions Directive address some of these challenges? Are there gaps that Portugal have to look to and fill?
Well, Joana, good morning. Thank you for the introduction, the organization for the invitation, and welcome all. I don't think it has, or not entirely. And that the fault is actually to find in the directive, because it has to do with the goals of the directive. So the main goal was to for all member states to have at least one mechanism available to consumers. And that goal, as Rita explained, had been accomplished in Portugal for a very long time, since '95. On the other hand, the directive aimed at setting minimum standards, and it left a lot of discretion for the member state to actually design a new mechanism to make it part of the existing one. And so while the implementation of the directive in Portugal, it obviously brought some changes, but it didn't represent like a radical overhaul of the system.
Okay.
And that is, and in particular, so the Portuguese legislator didn't take the opportunity to make like this general reflection on the system, on the existing solutions. And in fact, there were quite some comments from different entities during the public consultation phase about really critical issues that were worth serious consideration, but that weren't at that point. So on the other end, Portugal didn't take the opportunity to establish a single or a uniform regime. So we ended up with a patchwork of different rules that will bring some difficulties and challenges in terms of articulation of these rules. So I think, so we now have this new decree law that implemented the directive in December 2023, which supposedly applies to the infringements of the provisions referred in the directive. And I say supposedly because though that's what the Article 2 states, then the preamble says that it should also cover infringements to other consumer legislation. So there is no certainty as to the scope of this new decree law. Also, it doesn't offer like this complete framework because you will still apply on a subsidiary basis the class action law, the consumer protection law, the code of civil procedure. And then to all other infringements, you have different laws that apply, the private enforcement law that Rita mentioned, the security markets code, the class action law, of course. So I think it's kind of a confusing or kind of a mess, I would say. So what was kept the same, or more or less the same with implementation, so that the Portuguese legislator didn't take the chance to reflect on. Well, areas and sectors and companies that can be affected are the same before and now, because we did have this regime that would apply to all areas and sectors of the law. The opt-out system was kept, except for consumers not residing in Portugal, and that was an imposition of the directive. In terms of procedure, we didn't have back then, and we don't have now, a specific procedure applicable to class actions. So we basically apply the procedure which is applicable to individual actions. That is why we don't have a certification phase. We didn't have before the directive, we don't have it now, and that is why defendants have to present their defense both on procedural aspects and on the merits at the same time, same as in individual actions. In terms of damages assessment and distribution of compensation, I think that, well, the overall picture in Portugal, and to be fair, as in other jurisdictions, is one of great uncertainty. The directive basically kept the pre-existing rules with minor changes, so it didn't bring guidelines as to how the global compensation should be calculated or how it should be distributed amongst the consumers. It did establish a rule in line with the private enforcement law that the entity responsible for managing the distribution of the compensation can be the claimant itself or even simple consumer identified in the action, which is a solution that brings concerns, in my opinion, in terms of the lack of independence of the entity managing the compensation, but especially on the lack of judicial control from the court to this process of distribution of the compensation. Also, it kept a solution that the remaining compensation, so after consumers having claimed or not claimed their part of the compensation and after allocating to the cost of the claimant, the remaining compensation reverts within the new decree law now to the funds to promote consumers' interests and justice. So it basically underlined this deterrent effect rather than a compensatory purpose, which is something that it's kind of strange to our civil tradition. And then in terms of costs, this would have been a great opportunity to try to establish a more balanced regime. And in fact, the directive stated that member states should establish that the losing parties should bear the costs of the winning party, but within the limitations of the conditions of the national law. And we basically made no amends to what the regime that we had. So basically, even in cases where the action is entirely dismissed, there's severe limitations to the amounts that the defendant may recover from the claimant, even in cases where the claimants are supported by third-party funding, and that to me makes little sense. In terms of what have been changed, I would refer, if I have the time, 3 areas: so legal standing, funding, obviously, and also evidence. In terms of legal standing, what we have now, it's again a patchwork of different rules, so different legal entities, different legal requirements, depending on the infringement, depending on the applicable law. This new decree law brought a stricter requirements when comparing to the previous one, and stricter to cross-border actions than to domestic actions, which doesn't make much sense also. So for the purpose of domestic actions, we don't have qualified entities. I'm not sure if that is even compatible with the directive. We do have legal standing attributed to associations and foundations, provided that they meet the requirements that were already foreseen in the class action law, but with 2 additional requirements that are quite relevant, I would say. So the claimant must be independent and not influenced by third parties that have an economic interest in the proceedings, and it must adopt procedures to avoid this influence and to avoid conflict of interests. Unlike the collective action law, the new decree law doesn't grant legal standing to individual consumers, and I've already heard someone defending that basically you can either go use the new decree law or use the the class action law, and in that case, class action can actually be brought by a consumer. So a lot of uncertainty, even in terms of legal standing. In the context of cross-border actions, there we have qualified entities, of course, in compliance with the directive.
Yes, we will cover the cross-border particular issue in the final round. I don't know if you want to add something else.
No, just in terms of funding, that is probably the main area everyone is interested in. So as we didn't have any regulation whatsoever until December 2023, and there was this huge debate on whether it was admissible under the legal and constitutional framework, and I'm sure that part of that debate will go on. But we do now have some regulation, and the new decree law establishes that so the claimant must make the funding agreement available to the court, and I would say to the counterparty as well. That very important, the funding agreement must guarantee independence and absence of conflict of interest, and the new decree law clarifies that a claimant will be deemed independent whenever it has the exclusive responsibility for taking all actions in the proceedings, including bringing, appealing, settling the proceedings. And any clauses that don't comply with the legal requirements will be deemed null. There's it also states that if a claimant is not independent, if there's a conflict of interest, if the funding agreement doesn't comply with the rules, and if the claimant doesn't introduce any amends ordered by the court, that will have an impact on legal standing, which was something that we all had been arguing before the regulation was introduced, but was refused by the courts that understood that it wasn't a matter of legal standing and left bigger decisions to the end of the proceedings.
So, Sofia, I would say that it's clear that the main characteristics turn our jurisdiction attractive to class action, although there are gaps that should be or must be considered still.
I think to sum up, I would say that we have a very claimant-friendly regime that hasn't managed the right balance between actually promoting consumers' access to justice, but while also guaranteeing safeguards to avoid abusive litigation. And the numbers that Joana will address, I think that they reflect that.
That's interesting outcome. Joana, turning to you, I think it would be interesting to have some figures here, and I know you have them to share with us. How are these figures of these features of Portuguese legal framework for class actions being implemented in courts? This one question. The other one is about the industries or sectors where are these class actions being more relevant?
Yes. Thank you, Joana. Thank you for your presentation. And thank you also for this invitation. I have seen past symposiums, and it's always a great experience, and it's a pleasure to see that this year this is in Portugal. Yes, so I will bring some features and some experience of what is happening at the Portuguese courts. Rita just announced that I would bring some data, and I hope not to forget anything and not to frustrate expectations. But what we have seen is, so we have legislation from the 1990s, court experience for a couple of decades, and what we have seen is that class actions have already been tested across a variety of subject matters and sectors. To give you some context, and especially to the international audience, the law of popular action was initially tested in the context of consumer protection. It was designed for for the protection of a lot of interests, including environment, cultural heritage, public health. So it was initially tested in the context of consumer protection, with first claims being filed against a telecom provider at the date, Portugal Telecom, by Portuguese consumer associations such as DECO. One of those was concluded with a settlement agreement that allowed consumers for specific services and benefits. Another interesting area where the Portuguese regime has already been tested is relates to securities claims. So in the wake of the financial crisis and the measures that were applied, the resolution measures that were applied to Portuguese banks by the Portuguese, the Bank of Portugal, this triggered a series of class actions by retail investors or associations representing retail investors for the breach of information duties and regulatory aspects against financial intermediaries, members of the boards, supervision entities, and so on. I think it's also interesting to mention that there's already some experience in Portugal with environmental claims, mostly within administrative courts, but in past experience we have already seen claims, for example, to challenge the exploitation of oil in Algarve. So what we see is that the past experience before this more recent boom has covered a lot of different sectors and subject matters. And yes, what we also have seen is that in more recent years, class actions have increased in Portugal, not only in number, but mostly in terms of value of the claims and sophistication of the claims and the range of sectors and subject matters. Just to give you some numbers that Rita just announced,
yeah,
and I don't want to frustrate expectations. So, for example, between 2007 and 2021, the average number of class actions being concluded in Portugal was, per year, was 16. What we saw in 2023 was 68 class actions being concluded in Portugal. In terms of class actions being initiated, in 2022, there were 39 new claims, whereas in 2023, this number rose sharply to 135 claims. And the statistics available for 2024, they show that this trend of increasing class actions is here to stay. What about, and you asked, Joana, what about the new areas where this has been seen? So first of all, those that have been subject to European legislation, competition and data protection. Competition claims in Portugal are by far the ones that are involving the highest numbers in terms of the value of the value of the claims. These may be estimated to amount to tens of billion euros at this stage, and they are involving different sectors from technology to energy, telecoms, gaming.
Those are numbers for Portugal.
Those
right?
are numbers for Portugal. And then, and of course, so this was a result of specific regulation for competition, and as our keynote speaker, now we have for each right a remedy, and that is becoming a practice for the European legislator, and that happened for the competition claims, together with a Portuguese competition authority, which is very active. Another new trend relates to data protection claims. These involve, for example, the one that was filed against Facebook, which was settled more recently. I think that Rita was mentioning this one, and now a more high-value one that was filed against TikTok. And then we can also see that general consumer protection claims based on the Portuguese law of consumer protection or unfair practices in those types of regulation. These are also increasing and are extending to new sectors, to retail, to telecoms, etc.
We are running out of time.
Yes, just
and I would like to do a final round and then open to Q&A. But please,
yes,
Joana, if you want to conclude.
Just wanted to conclude, just saying that, yes, I've mentioned that there were a lot of claims that were concluded, but this does not mean, as Rita has just announced, that there are decisions awarding consumers the payment of quantities. So what we see in the court practice is there are a lot of decisions that relate to a preliminary, a control over the claim and over the legal standard at an early stage. And a lot of times it happens that the case is dismissed at an early stage because it does not involve diffuse interests, rather individual interests, or there cannot be a judgment equally involving all the class. But this still poses challenges for the defendant, because typically this early control is made after the defendant files the statement of defense, where the defendant must also disclose its position on the merits and on the evidence. So this was one thing that I just wanted to highlight. And the other one relates also to what Rita has just announced, that yes, we have a recent decision from the Supreme Court. This involves Vodafone case that ruled against Vodafone and ordered Vodafone to reimburse clients of the overcharged services that were not agreed upon. What happens is that the decision did not address how the how the damages, these are not damage, but how the amounts would be calculated and how would they be paid to the consumer. And this also links to what Sofia said. In my view, one of the great challenges for the future is to address specifically this phase, the assessment of the numbers to be awarded to the consumers and how they will be managed and paid. And this also implicates a post judgment phase and maybe some judicial control.
Thank you so much, Joana. One of the key topics, especially for global companies, is, as Sofia was mentioned, the cross-border issue. So about this, has the directive been a game changer? Maybe I will start with you, Sofia, in what regards with the cross-border actions.
I've read that it has, or that it will be. I don't think it will, at least for now, especially in the broader sense of cases where consumers from different jurisdictions are represented in a single class action, and that is not a relevant criteria under the directive, but I think that's the one that it really interests me, and it's interesting to discuss. So in this respect, the directive says that qualified entities may bring proceedings in different jurisdictions, that qualified entities may join forces from different jurisdictions, join forces and bring a class action in a different jurisdiction. It also establishes, as I've referred previously, that whenever citizens don't reside in the member state where the class action is brought, then they must opt in. And finally, for this discussion, it establishes that the directive is without prejudice of the international private law framework. And so I see two problems. One, it has precisely to do with this, the private international law framework, including the Brussels 1 and Rome 1 and 2 regulations and regarding jurisdiction and the applicable law, because they were drafted and meant to apply to individual proceedings. I think they will be raising a lot of questions when applicable, when trying to apply them to mass arm class actions. And the other one has to do with the opt-in rule, because I've seen some studies from the United States where they conclude that a very small part of the consumers actually claim their part of compensation. Rita just gave a testament of that within that settlement. So I can only imagine that not a lot of people will be willing to opting in a different jurisdiction. But I'm sure that it will be attempted. I'm just not sure if it's fair to say that it's a game changer.
Okay, thank you so much, Sofia. Rita, any thought on that?
Well, I think first a brief clarification. The settlement that I mentioned was not in a Facebook case. It was in a professional association case. I do believe that Facebook case did not involve compensation to consumers, so I was not mentioning that well. So on the I agree with Sofia. I don't think that it will be a game changer, and especially because of this opt-in characteristic. I think that to be opt-in or opt-out is what really matters to the various stakeholders that need to be involved in these class actions. We don't have that experience in Portugal because we only have, well, apart from this new law, so far we have only have opt-out class actions. But from the experience that I have been exchanging with claimants from other jurisdictions, it is very, very burdensome. It requires heavy book building work to set up a class action in an opt-in landscape. So I think that will probably deter the stakeholders that are working on the claimant side. Again, consumers associations and especially funders from making so much use of this tool as they already do in Portugal in opt-out class actions.
Okay. Joana, just to close, what do you expect to see in the future for class actions in Portugal?
Well,
in
2 minutes.
2 minutes.
1 minute.
Or one, yeah.
Well, I think. Well, I look forward to see how this cross-border aspect will work for the future. I can also anticipate that in some areas that are now or have been recently regulated by the European legislator may also be included in collective redress protection. I'm thinking about the DSA, for example, or even
Cross.
No, I'm sorry. I forgot. Product liability directive. I'm sorry. So I expect that the new trends may extend to this digital area, and the fact that the product liability directive is now also including software products and machine learning products, that may be an area where the class actions will increase. And as I said, I think that we might in the future start testing the calculation of the payment in Portugal, and maybe the phase for the payments. Let's see. But this is clearly something that we still don't have experience.
Thank you. So I think it's clear that we are entering in the very challenged period with a lot of opportunities, but also, as I said, challenges. Now, I think that we have I don't know, Rachel, if we have time to a question from the audience.
15 seconds.
Yes, must be very quickly. No, it seems not. So, as a wrap-up, so let me just thank you to our three speakers for your highlights. I think we have a lot to reflect over them. And thank you for joining us, and I hope you enjoy the rest of the event. Thank you so much.
Thank you.